Good day. I am Matumi Muratova from the National Consumer Tribunal from the Registrar's Office, and I will be taking you through the debt review applications filing checklist. A debt rearrangement application is an application brought by a debt counselor on behalf of a consumer to rearrange the consumer's credit agreement obligations as agreed with the consumer's credit providers. The tribunal interrogates these settlements carefully as they contain illegal interest rates, repayment terms longer than the reasonable work life of the consumer, repayment agreements that do not settle the debts of the consumer, insufficient provisions for the consumer's living expenses, and unaffordable repayments. Now, with illegal interest rates, this would mean that it is something that does not conform with the requirements that is above prescribed limits. And with repayment terms longer than the reasonable work life of the consumer, it will mean that the consumer would likely be in a position to retire, but they will still be in a position where they are under debt review, and that is not ideal for any person that's trying to free themselves from debt review. With repayment agreements that do not settle the debt, this will mean the whole point of the debt review process has not actually succeeded. With insufficient provisions for consumers' living expenses will mean once the drafted proposals are forwarded to the credit providers, the remaining amount the consumer has to live off is not enough for them to actually be sufficient or successful. And we will go into the next slide where we will point out all the requirements in the circulars. Now we'll be speaking on the circulars that are required. They basically point out the documents required, the forms required. So debt counselors can use Circular 7 and 9 as a checklist to ensure that their applications will be considered. If any of the documents listed are not included in the application, then the order may be refused or the application referred back to the debt counselor. The list of documents on Circular 7 must be on the application served on the credit provider, except for the proof of service, which will naturally not form part of those documents, and therefore not attached to the application. The consent order must be in the new format, which is Circular 9. Now we're going to start with the first requirement, the first document required when filing a DRA. So it is called the consent order. This is the final order that will be signed by the tribunal member. No other signature must appear on this order. Only the tribunal member signs this order. The debt counselor must use the template provided by the NCT, and no other formats will be accepted. And most importantly, the debt counselor must ensure there's sufficient space on this order for the tribunal member to sign. The second requirement is the proof of service. Now, this is proof that the entire application was served on the credit providers. It will usually be a copy of the email sent to the credit providers with the application as an attachment. The date on which the email was sent to the credit providers must clearly appear on the email. The email must clearly indicate that the application is for a Section 138 order and has been filed with the tribunal, and the application is now being served on the credit providers. The correct email addresses of all the credit providers must appear on the email. Now, once this is served, it is very important to note that the credit providers are afforded 15 business days to provide an opposition should they wish. Now, please don't forget that a consent order is in essence something parties consent to. So if there's one party disputing this, then it is unlikely that the application will be successful. Now, third on the checklist will be a copy of the identity document. So this document must be clear and legible. And one important thing to note is that this is the only document we'll accept when it comes to identification. So a driver's license will not be allowed, not even a passport will be allowed. So the closest thing that could be accepted in that regard would be a temporary identity document. And the fourth document required would be the power of attorney form. So this is the form signed by the consumers, confirming that the debt counselor can act on their behalf in applying for the debt rearrangement order and can sign the application and repayment agreements on their behalf. If there are two consumers on the application, then the power of attorney must be signed by both consumers, or there must be two separate power of attorneys. The power of attorney is necessary when filing manually as well as through our CMS system. And it is important to note that once the consumer is to sign this power of attorney, they must provide those specific powers to a natural person, a living person. So it can't be the DC firm, it can't be the DC company, it can only be the actual debt counselor. And now, fifth on the list is the acceptance letter. So this is the letter signed from each credit provider accepting the repayment proposal made by the debt counselor. The signature may be electronic. The letters must appear on the application or be filed in the exact order as they appear on the consent order. So, for example, if the consent order includes A, B, C being those three credit providers, when you are filing the application, they must be in that order as well. And number six on the checklist is the draft consent order. So this draft consent order must be signed by the consumer or the debt counselor on behalf of the consumers, but only if there is a power of attorney that has mandated the debt counselor to act on behalf of the consumer. And seventh on the checklist is the repayment proposal sent to the credit providers. Now, this is a signed and dated copy of a Form 16 that is sent to the credit providers. And this lists all the credit providers and the repayments proposed. And number eight, we have the income and expenditure statement. So this is the form setting out the income and expenditure of the consumer and the amount available for payment to credit providers. Naturally, this information forms part of the Form 16 that is sent to the credit provider. And with the expenditure statement, so basically everything is listed from the petrol one pays to the repayment for a home loan or the child's school fees, if those are applicable. And we move on to the next item on the checklist. So that would be the NCT application form. So this is effectively the only form because everything else should be provided by the debt counselor up to now. So this is a form that is fully completed, dated, and signed by the debt counselor. So in this form, the debt counselor will be able to identify themselves as the facilitator. And unless you are filing via CMS, this form won't be generated for you. And we go on to number 10, which is consent to service. So these are copies of a standard letter from each credit provider confirming that they consent to service via email. This consent often also appears in the certificate of balance, and if that is the case, then a separate one is not required. And another document that we require is the proof of fee payment. So this is proof that the filing was paid to the tribunal. So this is usually a copy of an EFT payment made to the tribunal with the ID number of the consumer filing manually. So this is not required when filing with CMS, as we have what we call an e-pers. So in the e-pers, as long as you have enough with regards to an application fee, then you can file. The application will go through without a problem. So those were the documents and the forms that were required to successfully file an application with the tribunal. So now we're going to go into the common problems experienced when filing with the tribunal and which may lead to the application being refused as a result. So the first one will be the name and identity number of the consumers. So these must match the information that is provided. So the consent order and the ID number that appears on the document must match. And with regards to the names, it should be the name and then the surname of the consumer, which must appear on the consent order, not surname and then the names. And in instances where a married consumer has not formally changed her surname, the surname as it appears on the ID document must reflect on the order. So this would mean that if you are married and you still haven't changed your surname, you have to use your maiden one. So another key issue that a debt counselor filing party must be aware of is that the names and number of credit providers listed on the order must match the number and names on the acceptance letter or the Form 16 proposal. All the credit providers listed in the proposal must accept the proposal. If any one credit provider does not accept the proposal, then the order will be refused. So this could mean that we refuse it because we've received an opposition, or we refuse it because they simply do not match as already stated. So this generally occurs when, for example, the debt counselor engaging with the credit provider gets basically a provisional acceptance letter, and obviously it gets deemed as a final acceptance letter. And then from then on, the credit provider tries to clarify that. And by clarifying it, they would have to bring an opposition. So that is basically the most important thing to note. And the other point here will be that the complete and legally registered business names of the credit provider reflected in the acceptance letter must match the name on the order exactly. So it can't just be First National Bank, it would need to be First National Bank, a division of First Rand Bank Limited, or it should be ABSA Bank Limited and not simply just ABSA. So we'll be moving on to the next slide now. So another problem that's been noted and is being highlighted is one where the credit provider's correct company name tends to become an issue for debt counselors. So the credit provider's correct company name must appear on the order, not the agent or the debt collection agency. The name of the agent can appear in brackets after the credit provider's name is, if necessary. So it will be true words, and in brackets you say an agent for credit provider consumer friend. Only the name of the credit provider must appear as a party on the order, not the type of loan. So now we'll be speaking on interest rates. So the interest rates on the order and acceptance letter must not exceed maximum interest rates. A higher interest rate will only be permitted if the original credit agreement agreed to clearly state that this higher interest rate is fixed for the period of the loan. A copy of the original agreement must then be attached to the application to show the fixed interest rate. So another thing to note with interest rates is that they do get periodically updated or increased. So there's a maximum prescribed rate document that will be provided, and the debt counselor should do well to make sure that they're aware of the most recent ones to avoid refusals. And that completes what we've been getting into today. Thank you very much.